Good day everyone, good day ma'am. I am Elaiza Taculod from BEST Agent 3B, and right I'm going to report to Chapter 5 entitled Law on Sales, Agency, and Credit Transactions. Agents should ideally work for the best interest of the client. Because of the trust given them, agents initiate actions, administers, and collect on behalf of the client. So we have here the learning objectives. First is to describe and explain the nature of sales transactions. Second is identify the functions and operation of agencies in the industry. And lastly is identify ways of handling credit transactions. Law on sales. In the tourism, travel, and hospitality industry, agreements arising from contracts will have to be made, and potential breach from these agreements will be encountered. A contract of sale is one of the usual contracts being encountered by the industry concerned. This will give you an overview of the different sales transactions which may be encountered, including the remedies of the parties concerned. Article 1458. With the contract of sale, one of the contracting parties obligates himself to transfer ownership and to deliver a determinate thing and other to pay, therefore a price certain in money or its equivalent. So a contract of sale may be absolute or conditional. So we have here also the discussion of the law. So we have here the characteristics of a contract of sale. Characteristic of a contract of sale. So first we have here the consensual. It's a contract of sale is perfected by mere consent. No form is prescribed for the perfection in a contract of sale except in the following instances. We have here those covered under the statute of frauds which must appear in writing, otherwise the sale is considered unenforceable, and also sale of real property made through an agent, in which case the agent's authority must be in writing, otherwise the agency and sale made through an agent is void. So second is we have here the bilateral, because it gives rise to reciprocal obligations, and third is principal, because it can stand by itself without need of another contract. Next is onerous, because of the consideration of each party is the delivery of the thing or the payment of the price. And the 5 is commutative, because what the vendor or seller delivers is considered equivalent of the price paid by the vendee or the buyer. Number 6 is we have here denominate, because it has a designated name under the Civil Code of the Philippines, which is sale. And 7 is transmissive of ownership, because the vendor transfers ownership of the subject matter to the vendee, which is the buyer. So we have here the requisites of a contract of sale. Requisites of a contract of sale we have here. First is the consent. Consent is manifested as the meeting of the offer, which must be certain, and the acceptance, which must be absolute, upon the thing and the cost which are to constitute the contract. So we have here the following are disqualified to enter into a contract. So first is husband and wife. A sale between husband and wife in violation of Article 1490 is inexistent and void from the beginning, because such contract is expressly prohibited by law. So the following persons cannot acquire by purchase, even at public auction or judicial auction, either in person or through mediation of another. So the guardian or the property of the person or persons who may be under his guardianships. Agents as the property whose administration or sale may have been entrusted to them unless the consent of the principal has been given. Executors and administrators, the property of the state under administration. The public officers and employees, the property or state or any of the subdivision thereof, or of any government owned or controlled corporation or institution, the administration of which has been entrusted to them. And justice and judges, prosecuting attorneys, clerks of superior and inferior courts, and other officers and employees connected with the administration of justice, their property and rights in the litigation or levied upon on execution before the court within whose jurisdiction or territory they exercise the respective function. Any others especially disqualified by law. Contracts entered in violation of the above shall render the contracts void by reason of public policy, and because such contracts are also expressly prohibited by law. So we have here the application of the law. We have here the object or the subject matter. So the requisites are also follows. It must be existing or possible, and it must be licit, and it must be determinate. In a contract of sale, the thing and the price are the subject matter, and the price must be understood to be in money or its equivalent. So next is the cost or consideration. It represents the why of the contracts, the essential reason which moved the contracting parties to enter into the contract for the seller. The consideration is the price certain in money or its equivalent. For the buyer, the consideration is the thing in a contract of sale. Moving forward, we have here the effect of loss of the object in the contract of sale. So the law, Article 1480, and any injury to or benefited from the thing sold after the contract has been perfected from the moment of the perfection of the contract to the time of delivery, that shall be governed by Article 1262. And Article 1262, an obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before he has incurred in delay. So Article 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him in any manner of the ways specified in Article 1497 to 1501 or in any other manner, so signifying an agreement the possession is transferred from the vendor to the vendee. So we have here the discussion of the law. So if the thing is lost before perfection of the contract is considered inexistent. Therefore, the loss is borne by the seller based on the principle of res spirit domino, or it is the owner of the thing who bears the consequences of the loss. Second is if the thing is lost at the time of the perfection of the contract shall be considered without any effect, and the legal effect is the same as the object is lost before perfection of the contract of sale. So third is if the thing is lost after delivery, the buyer bears the risk of loss since delivery transfers ownership. So the following principle of res spirit domino. So fourth is if the thing is lost after perfection but before delivery, the seller bears the risk of loss since there is no delivery yet, hence no transfer of ownership to the buyer. So this is considered just and equitable, being more in conformity with the principle of res spirit domino. So in this case, the buyer may demand the return of the price in case payment has been made. So the reciprocal nature of a contract of sale dictates that when there is an obligation to deliver a determinate object. Therefore, once the obligation to deliver is extinguished, the correlative obligation to pay the rule, the price is also extinguished. This rule will apply even if the thing is lost through a fortuitous event or even without the fault of the debtor. Moving forward, we have here the sale of personal property payable in installments. So it is possible that in buying personal properties used for public transportation or delivery of goods, buses, cruise ships, FX, undelivered trucks, this provision will be useful for the contracting parties in case of sale or personal properties payable in installments. So we have here the laws, Article 1484. In a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies. So first is exact fulfillment of the obligation that should the vendee fail to pay. So cancel the sale that should vendee's failure to pay, cover 2 or more installments, and foreclose the chattel mortgage on the thing sold if one has been constituted should the vendee failures to pay cover 2 or more installments. So in this case, foreclose the chattel mortgage on the thing sold if one has been constituted should the vendee's failure to pay cover 2 or more installments. In this case, he shall have no further action against the purchaser to recover any unpaid balance of the price. So any agreement of the contrary shall be void. In order for the above provision to apply, to the following requisites must concur. So contract must be of sale, absolute sale, and not a contract to sale or a contract of loan or a back to the retro transaction where redemption is effected in installments. So what is sold is personal property, not real property. And the sale must be on an installment plan, so it must contain at least 3 installments. If the sale is for cash or on straight terms, here after an initial payment, the balance is paid in its totally at the time specified. So Article 1484 does not apply. So next is we have here the double sale. So caution should be practiced by real estate developers engaging in the hotel industry, especially in real property located in potential yet unexplored provinces. The principles on double sale will be useful in case an issue on a sale of a real property to different vendees shall be brought before the courts of the law. And that's the end of my report. Thank you and have a good day.